Hello, everyone. Welcome to Let's Talk World Talk Show presented by Flick of the Creators. I hope you guys can sense that I'm sort of going through cough and cold today. A bit low on energy, but never low on content to be with us. Today, we have Mr. Ishant Shah with us. Mr. Shah is the managing director of Flex Concealer, a growing law firm based in Mumbai with recent expansion in the city of Ahmedabad, that's Gujarat, India. He has more than 10 years of experience, that is precisely 14 years of expertise in the infrastructure sector, corporate sector, IT, commercial arbitration, scheme matters, IT sector, and so on and so forth. He's the in-house counsel of Lex Conceder, and during his 14 years of practice or experience, he graced the opportunity to work on diverse and complex projects. We are going to talk about all of this. And one important, or rather, I should say, interesting thing that we always tend to look for. He's a first generation lawyer. So we have a lot to discuss and talk about his journey. And hence, without any further ado, let me introduce you to the man himself. Hello, Mr. Shah. Welcome to the show. And how are you doing, sir?
I'm doing great. How are you doing?
I'm doing good, sir. You see, it is what it is. I mean, pollution is just killing me. Other than that, everything. And thank you very much for joining us for the session. It has been a great pleasure. Technology is not really working in favor of us, but I really appreciate you being such a support. And as you can see, I tried my level best to cover things about you, Mr. Shah. But it's not really possible for me to put everything of your journey in my little few words. So let's get started. First thing first, I actually had a different question, but I'm going to ask you a different question because you're a first generation lawyer. So my very first question is why law? Why not something else?
Well, to put it very precisely, you can call me as an accidental lawyer. The reason I say so is I need to come from a diamond industry business, and I was quite busy making my career in the diamond industry prior to 2007. And under the guidance of my late father, who happens to be my mentor, he just advised me to enroll for law course as an additional qualification. And just following his advice, at that point of time, without any intention or to become a lawyer, I just enrolled into the course. Then in 2007 and 8, as we all know, we had a recession world over. At that time, I switched on. I started dedicating myself to the service industry, that is basically the profession of law. And gradually, when I was studying, and I started developing a good interest, and I really developed an interest, and then I decided that yes, I want to be a lawyer, and this is how the journey began. And after practicing under solicitors and counsels for 3 to 4 years, I set up my own law firm, Lex Counselor, and I've traveled a journey of a decade. That is how the journey has been. It has been a good journey so far.
Yeah, I can bet on it. That's really wonderful, sir. Running down into your practice, rather I should say your cases. So if you can tell us about a complex or rather interesting legal issue that you recently worked on and describe the complexity around it and how you really worked on it. What was your approach?
Well, I had an occasion to handle or work on various multiple complex issues in my journey of more than a decade. But I would like to share the very recent one, the case which we handled during the pandemic. This was a case of a cross-border transactions between our client, being an Indian listed company, who contracted to purchase certain materials from a South Korean company, materials which were manufactured by an European company. This entire transaction was covered by letters of credit issued by an American bank to be discounted by a German bank. The material was to be received in two shipments. The first shipment was received, the letters of credit was honored, everything seemed to be going very fine. We developed trust on the South Korean company who was supposed to supply the second shipment as well. So, under the good faith, they transferred the document to us for honoring the letters of credit. We accepted the documents in good faith. The said documents were discounted. The letter of credit was discounted by the Korean company from a German bank. But what happened was something shocking subsequently, that we never received the shipment on the due date. Now, this was a difficult situation for us for the reason is the transaction was covered by a letters of credit and bank guarantee, which has to be honored under all the circumstances, and the law being very settled internationally as well as in India, that the courts generally do not intervene in such kinds of transactions, with only two exceptions being carved out, one being the force majeure and the other being a case of a serious fraud. Now, with all these difficult situations, all odds and all documents, and our conduct itself running against us, we had to save our client from honoring the letters of credit, which was running into crores of rupees. So we went into the boardroom, devised our strategy, rather than leveling any allegations or insinuations against the Korean companies, or getting into any kind of alligating correspondence. What we did is we adopted a different strategy by rather engaging with them and persuading them to assure us to supply the goods for a future date, and obtain an indirect admission that the goods were never supplied to us or shipped to us. Somehow we were able to succeed and overcome that hurdle first, and we were able to obtain an indirect admission. But then there was another challenge: is to convince the Bombay High Court intervene in a transaction which is covered between various different countries. It is governed by the international laws as well as the Indian laws, and the law running against us at the same time. And we had to somehow carve out an exception that this is a serious case of a fraud. We approached the court based on the indirect admissions made by the South Korean companies. At the first instance, the court was not convinced and not willing to intervene, saying that this being an independent contract, we would not like to intervene and let it be honored, and you can recover your dues in due course. However, we pushed hard. We tried to satisfy the court. At the end of the day, we satisfied the court. We carved out an exception saying this is a serious case of fraud and it requires intervention of the court. And ultimately, the Bombay High Court, being unconvinced, intervened, restrained the American bank from honoring the letter of credits. And this is how we saved our clients from honoring the letters of credit and saved the crores of rupees. What we learned from this matter was that it is not always advisable and good to just get into an allegation modes or counter allegation modes. Sometimes you have to use a strategy persuading your opponents to get into your correspondence and get those admissions, direct or indirect, which will help you in getting your results. This is how we were able to manage and get this trading order from the Bombay High Court.
That was mind-boggling for me and I for my viewers with finances. I mean, finance plus law. It's a deadly combination, I believe. Now, Mr. Shah, thank you very much for sharing that. Now it's time to have your takes on few things when it comes to legal fraternity. I'll start with the virtual proceedings and availability that we saw happening while the pandemic were there. And I believe it was a very positive thing that came along, ironically, with pandemic. What do you think is this sustainable and a possible way to increase access to justice in your opinion?
Well, I believe technology will go a long way in the judicial system. To term it as in a punchline, technology and artificial intelligence is now going to be your business partner. You just cannot think to live without artificial intelligence or technology. We have to live with it. We may become slaves to the technology, but still we'll have to live with it. Now, just to share my experience during the pandemic. Well, if you look at pre-pandemic period, the traditional way in which the courts all across the world, including India, the traditional manner in which they function. And today, when we look at technology being used and distance being no barriers, the first advantage has been that justice has become accessible to remotest of the areas in the country like India, which was not possible prior to pandemic. So that is the first advantage that technology has brought in. Second is because of the cutting down of the distance, and we saw the court cutting the ice, from moving from traditional way to the modern ways of using technologies in conducting the hearings. What we have seen is that the justice is becoming more and more cost effective. That also enables more and more citizens to access the formal judicial system because it becomes cost effective. So these two factors will really have played a great role, and we do see a good future for Indian judicial system. At the same time, yes, this is the way we are going to leave now. It is not only sustainable, but this is going to be the way for the future.
That's a good take, sir. I still believe that there's a infrastructural issue that, I mean, is to be covered, but the intent is there. According to a lot of lawyers, the intent is there. It's just that it will take its own time.
Just to intervene.
All right, so on the count of three, we'll do it. 1 and 3. Well, Mr. Shah, thank you very much for giving your take. I mean, it sounds wonderful, especially when it comes to a lawyer to a stature. But still, to add on, I believe the intent is there, but it will take its own time because of the infrastructural issue that we all are aware of.
Yes, certainly, it will take time. But as I said, we have to learn to live with it. It's going to be our business partner. We just can't think living without technology. But now, if you look at the initiative, especially by the government of India, they are moving at a very good pace in inducting AI in the field of judiciary. First thing is the virtual hearings have now become a norm, which used to be an exception pre-pandemic period. That is the first thing where they have cut the ice. Second thing we see, especially all the law firms across all the states in India, they have started going paperless. We all have now started functioning in a digital modes. We have all our digital files with iPads in the courts. Like it's become so easy for us to now access our records, conduct our hearings. Then again, today distance is no barrier. I can be in any corner of the world. What bare minimum I require is a good internet connection and a good device just to connect and conduct my hearing, and I'm available at the tip of that. So, what I personally believe is technology is the need of the hour, intent is there, and action is also there now. May not be visible immediately, but down the line, 2-3 years, we will see a visible change. Few changes I can suggest, I can highlight is that the database management which the government of India has introduced, e-coach system, where entire case details are available on e-coach at the tip of a finger. You need not go to any courts, did not even open your papers. At the tip of a finger, you have your entire database available with all the order sheets, your daily sheets, updates, stages, everything available over there. Secondly, as I said, yes, the virtual hearings being conducted, third is digital files now. All the court records are also now being converted into digital records today. So yes, it is going to happen very soon. I don't see it quite far away, but next 2-3 years, we're going to be completely into virtual mode.
Well, fingers crossed, fingers crossed. If we talk about other than the technology inclusion in the legal fraternity, uh, how would you rate the current legal system's drive towards encouraging access to justice? First question in this is there a gap? Is there a justice gap? And if there is, what's the tangible movement in terms of closing that justice?
And it correlates to technology only. But yes, the gap is, we cannot deny this fact. Yes, how do I rate the drive? We can say it is at the nascent stage. A lot of efforts are being made to bridge that gap. Technology will definitely play a pivotal role. Apart from technology, we can say other factors like education and urbanization. That's the need of the hour. That will also play a pivotal role where, when you educate your citizens and apprise them of their rights, so they can access, formal judicial systems and encourage them to access more and more formal judicial system by awareness. Like I can give you an example of social media. It has played a very important role over a decade, and it will continue to play over the next few decades in educating and imparting awareness among the people about their rights, etc. Then today with internet, all the law books, law information, repositories, everything available on internet at tip of a finger. This again, goes a long way in bridging that gap. Then you can also talk about the NGOs, which have played a very pivotal role, in imparting education among the citizens who are generally not educated. And they have played a very pivotal role in the sense they impart education about, and tell them about their rights, generally, which they are not aware of. So even they, by that education, try to access the judicial system. Where in all this technology will play the role is by making judiciary very cost effective. That has been a deterring factor world over, and India being no exception. Making judiciary available at a very cost effective manner is very important, which enables every citizen to exercise the formal judicial system. It is at nascent stage, but it will grow rapidly in the coming years. And technology is going to be the, you can say, the third baby for us, who's going to play the very, very important role in bridging this gap.
Yeah. So I think it's going to be a driving force in taking it very, very important.
Yes.
And I also believe that generally, whenever we do these sort of discussion about justice gap and things like that, we always think about the number of pending cases in court, the number of judges to the ratio of the number of cases that are there, and all these factual numbers. But there is one more fact that we always miss as a civilian, which I think, correct me if I'm wrong, it's about the awareness. I mean, it's still the saying is same, you don't my father still says that stay away from lawyers, doctors, and police. I mean, we are not law-loving people. That's what I believe. Uh, I'm not sure how to really put it, but that's what I feel. There has to be a lot of awareness in terms of what our rights are, and it's not a business where you will be engulfed with a lot of things, with the dates and everything. Rather, it's a thing of our own rights, and we should utilize it, and we should know how to utilize it. I hope I am doing the right way in this approach.
Yeah, it is correct way. The reason the previous generation, or you can say rather older generation, carry that stigma of not approaching the courts of law is because of the delay in delivery system, especially in judiciary, the lag. But that's we have to even understand and address this situation that we, especially in a country like India, with a population of 1.4 billion and with limited judicial infrastructure, limited number of judges, limited numbers of attorneys and lawyers and counsels, the pressure is always going to be there. That's why I reiterate and say that this is where the technology will really, really come into picture and will be really of a great assist, where this can really take off the pressure of the judicial infrastructure. But yes, I can just put one figure before you. The various efforts made by the recent government of India is in 2015, 1.33 crore cases were settled via Lok Adalat. This is a settlement forum where the judiciary makes an efforts and attempts to settle the matters amicably, try to convinces the litigants on both the sides that settling the matters is much more advisable than fighting for a few years or maybe sometime for decades, and just settle your matters. And the success ratio was quite good. A lot of efforts are being made not only through judicial system, but government is making, or rather coming up with various alternative mechanism. For example, arbitration is an alternate mechanism, conciliation, mediation, lok adalat. Then to put it, for small and medium scale industries, they have come up with a mechanism for online filings for recovering your trade dues with 3 times the penalties. So a lot of efforts are being made, and internet has played a great role in creating awareness. And going further, I believe we will see more and more people accessing the judicial system, the formal judicial system, to put it more precisely.
Well, that's a very good note to end this answer with. Mr. Shah, when we also talk about business, we generally look at the financial aspect of it, what the government is doing on the financial end, but we forget that compliance and law is an indirect mode of getting revenue, both for independent and the corporate. Could you please tell us about few of the initiatives taken by the Ministry of Law and Justice in the present government of India towards ease of.
From a legal perspective, I can just highlight few of the steps taken by the government of India. In the line of ease to do business, they have repealed various absolute laws which were existing in the rule books for years together, which were never even been put to any test or utilized. That was the first step. Simultaneously, they have inducted and introduced various new laws which have been of real great assist. Just to highlight, one of them is for expeditious disposal of commercial disputes. The government of India came out with a Commercial Courts Act in the year 2015. The idea and purpose behind introducing the law was to ensure that the disputes are resolved within a time frame of 1 to 2 years. And there has been a great achievement as far as that law is concerned. What they have done is by introduction of this law, they have put up a time frame for every procedural aspect to be performed during the conducting of the hearing, which ensures that the entire exercise from the start till the end, when the judgment is delivered, is a time-bound exercise, and you get justice in a time-bound manner. Apart from that, it has also done one thing is that it has made commercial disputes more cost-effective by introducing this act. So what happens is more and more people come and access the judicial system. Otherwise, because of the cost factor, especially when we look at arbitration, which is termed as a luxury litigation world over, because of its, escalating cost and, of the arbitrators with the councils, it becomes a luxury litigation, to be more precise. Commercial Court Act has done away with that. It has made judiciary more cost effective, and with, time-bound exercise, it has been a great success. Now, in the line of arbitration, it being a luxury litigation, and it also had a very, you can say, previous to amendments in 2015, especially in India, arbitration used to go on for years together with no time-bound exercise. What the government has done is in 2015-16, with new amendments, they have again made arbitration in time-bound exercise, and it needs to be completed in a span of 2 years, with 1 year being the first deadline, and then you can opt into extension. This has been a good amendment. Another step what they have taken is, in the line of making arbitration cost effective, is they have come up with a upper cap of the cost of the arbitration, especially in terms of fees of the arbitrator. So they have some way controlled it, but it requires, further initiative to make it more and more cost effective. So that area needs to be addressed. Apart from that, what they have done is they have reduced the intervention of the court in arbitration proceedings. Otherwise, what we used to see previously is every order of an arbitrator used to get changed, and then the matter used to go to the court, and then the arbitration should have been pending. So what they have done is, by virtue of this amendment, they have reduced the intervention of the court and given ample powers to the arbitrator to decide each and every aspect of the matter. And if at all anybody is aggrieved, you can go and challenge, that is Section 34 for the High Court. There are other laws which have been introduced. I mean, you can say, as I said, law for small and medium scale industries. Generally, business segments, in the small scale and medium scale, they do not like to access judicial systems. The reason being, it being an expensive affair. So by introduction of this law, what they have done is they have put up a mechanism which is completely online, which does not even require assistance of a lawyer at the very first instance to get your dispute resolved. And it has a deterring factor that a defaulter will have to pay 3 times the penalty if they do not make timely payments. So with this, what has happened is it has opened a gateway for the small and medium scale industries to access the formal judicial system at a very cost-effective manner. And again, the disposal happens in 6 months. So it's a very, very speedy disposal. There are many laws this is a never-ending list. What, the recent government has done is, the another one is insolvency and bankruptcy code, which has really gone a great way in clearing the balance sheets of companies, banks, and is now creating a very vibrant environment in India. So this is never going to be a never-ending list. There are a lot of initiatives, but yes, these are the 4 which I can, highlight. The very good initiatives which I appreciate, and we hope that the government of India continues with that.
I mean, yes, correctly said. Common man, even as the young lawyer, generally, I guess lawyers miss on these things. But thank you very much for getting this into the light. And I guess if anyone wants to learn more about it, they can always write down the information. I guess it is publicly available now. Now, every question that I've asked, Mr. Shah, it has a pinch of technology in it, or rather, I should say more than a pinch of technology in it. So let's come down to the legal technology. Uh, pandemic worked as a catalyst in terms of bringing legal tech to the Asian country, let me say so. And we are in the middle of era of technology. In this era, what are those tools, those most commonly used tools for you to make tasks easy?
There is a leg.
There was a leg. Okay.
Yeah.
Every question that I've asked you, Mr. Shah, so far had a lot of technology incorporated into it. Now, I will be asking you about the legal tech, which ironically came along with COVID to the Asian, uh, to the Asian legal fraternity, I would say. In this era of legal technology, what are the most commonly used tools for you to make tasks easy?
Well, I will name few of them. Basically, even before pre-pandemic, we were quite used to technologies, and we were looking forward to using technology in our firm. So one of the mostly used software in our firm is the lawyer services. It manages our entire offices. To name it, from our board management, our case managements, our order managements, daily sheet managements, our invoicing, reminders to our clients for payments of invoices directly is handled by the software. We do not even bother for a moment that whether we have to send reminders or not. The software works in a manner that on a set timely reminders, it does send a reminder to our clients that XYZ or maybe certain bills are outstanding for particular work. Apart from that, this is a software I really like. His reason is we have our board for the next day, a day in advance on our emails, on our SMSs. So we know what are the matters that are going to be listed tomorrow, and our team is ready with their preparations for tomorrow. We did not depend upon the traditional ways of just scrolling through the papers of your physical diary and all that. Today, everything is at the tip of the finger. Even if we are traveling, we can just access our email, our boards, everything is available with us. Our digital files are available with us. So this is one software. Then it also, keeps you posted about all the latest developments. It also has a feature of research engine for, carrying out search for all the latest judgments. So this is the widely used software enough. Apart from that, we have another 3, 4 tools that we use is like for legal research engine, which is quite commonly used in the legal fraternity. So we do use Manupatra, and we have started using Live Law. It's a very good software, which I believe keeps you posted with all the breaking news of happening in the courts across all the states, across the country. So it's like a media house for us. It keeps us posted about everything that's happening in the nook of the corner of each and every court. So that's another software. That apart, we have our own in-house softwares, which manages our digital papers, allotting them the case numbers and keeping tracks of other matters, stages and everything, keeping tracks of all the papers being scanned and not, and, converted into digital files, bookmarked or not. So these are the softwares which we use. And as I said, we have to live with it. We have already learned to live with it. We can't think living without it anymore now.
Yeah. Yeah, I mean, technology is now part of our life. Um, that's very rightly said, sir.
Yeah, we are soon going to be slave to the technologies. We are already slaves to the mobile,
Yeah,
and
yeah.
we're
I
going to be
mean,
slaves to the technology.
that is again a controversial question. I'll not dwell down into this, but I guess in some next session we can always talk about this. That are we living in are we in even in reality or the virtual reality or the augmented reality of life itself? Rather, that's a philosophical question more than a legal question. But I'll dwell down to something else, Mr. Shah, because 14 years of expertise in litigation. Uh, you've seen a lot happening in litigation and of course in other parts of the practice, arbitration, mediation. My question is just this. This is a very recent curiosity of me, and it was also a request from a lot of viewers. Mediation or litigation? What will you pick, and why?
Part of this mediation as a first answer. Though being a lawyer, litigation always beneficial for me. But when I look at a larger scenario, mediation is always preferable over litigation. Now the reason is very simple. moment you enter the arena of litigation or you dwell into the territory of litigations, you enter the courtrooms. We all know, be it India or any other country, litigation takes some time. Maybe it may be little slow in India, but fast in some other countries. But does take some time. Yes, it is an expensive affair. It also take away some peace of mind. The citizens or the litigants who enter the courtrooms, that thought always dwell in your mind. That I'm facing a litigation, or I have to face the litigation, and I need those released from the courts, XYZ released from the courts, and this always hover your minds. Mediation is something where you try to encourage the parties to amicably settle the matter, and try to pursue them and convince them that do shed away some of your rights, some of your claims, settle, move ahead with your life. You will save on your time, and you will be able to capitalize on that time, and capitalize on the opportunities which may come in future, which you may lose out by spending time in litigation. So mediation is always the first option, and litigation should be the last option. And this has been my practice for 14 years, what I've been advising my client to being a lawyer.
I've talked about this to a lawyer, and he and she said that mediation is not that successful. Even if you look at the rate, it's around 5 to 7%. Is that true? I mean, does that work as a pre-litigation phase? Because what other lawyers also mentioned, I'll not just pick one. Other lawyers also mentioned that maximum times after mediation, parties don't agree on any point, and then they come back to litigation. So they end up spending more time, money, and everything on a case, which if they started in, if they have reached to a litigant, then that would have reduced that time frame of mediation. What is your take on that?
I completely agree on this. Especially in India, yes, this is the reality. It's a stark reality, but it is a reality that exists. That the litigants are now developing an opinion or a view that it's a futile exercise to go into a mediation, because ultimately they end up litigating in the court, with no resolution in the sight. So, and the other opinion that they develop is, that they end up spending more on mediation, especially when the lawyers are involved. So, yes, this is happening, but nevertheless, we should never give up. We may require some sort of improvisation that how mediation should be conducted. We will have to address the areas of concerns, and I'm sure government is looking at it. But I still hold an opinion: mediation is the best way to go, and not the litigation. Success ratio in India has not been very inspiring, and that is the reason people do not like going for mediation. And just going back to I just mentioned about the Commercial Courts Act. That is the first step by the government when mediation has been made compulsory. It is mandatory to go for a mediation, and they have some way, other given a relief to the litigant, saying that whatever is the period involved in that will be excluded for the purpose of computation of limitation. And there, mediation is very cost effective because it's before the judge. It does not cost you. So, first step has been taken by the government. We have seen many a times that mediation has succeeded for commercial disputes, but yes, it's still a long way to go, and a lot of improvisation, brainstorming is required that how mediation should be addressed, how it should be conducted going ahead.
That I guess I did a great job in terms of asking both the questions, because these are two sides of the coin. I mean, generally we hear one side and then we think, okay, let's go for mediation. But then there's another angle to mediation that we also should think about. And I guess there's some bill in parliament regarding mediation. I'm not really sure about what it is, but I'll not talk about this. I don't want to sound like a fool talking about something that I don't know, but I just know the keywords around it. So, Mr. Shah, thank you very much. So far, this has been a great session. You having such a great experience being a first generation lawyer, making so good and so far coming so far in the industry. I would say industry. I would say the noble profession of law. I will not let you leave the session before I ask you question that will help the young lawyers and the students of law, which is What do you suggest to them if someone wants to pursue a legal profession or is in legal profession trying to make big in the industry? Also, if you can talk a bit about time management, because I guess that is a very major thing to understand for lawyers. So, over to you, sir.
Yes. As far as the time management is concerned, yes, that has been a great concern for lawyers over decades, But again, technology has played a very great role in it. You ask me personally, I use the principle of first thing first. When I start my day in my office, the first thing that I do is I prepare my list of priority and jot down the work that I need to do on the priority basis, using the principle of first thing first. And then I make use of my technology to enable me perform the work. But time management is still a concern for all the lawyers because it's a very demanding profession. At the same time, it is a stressful profession. You can say, especially in litigation. In litigation, yes, it's a stressful profession, and we are also working hard to address these issues. Now, as far as young lawyers are concerned, we have a very simple message. They should look at this profession as not as a career, not as a career. They should look at this profession for serving the legal fraternity, the citizens, because judiciary is one of the four pillars of a democracy and one of the most pivotal. If judiciary collapses, a democracy collapses, as we all know that. So therefore, we should not just look at it as an optional career or a career to gain some job or some position in a law firm or something. You should try to make your career, and especially young generation, they should focus more on litigation, learn trials, learn how the matters are conducted rather than just going and sitting in corporate offices and sitting on the computers and just learning few laws and having those boardroom sessions which don't help you and glorify you as an advocate. So our tip of advice to all the young lawyers: go through that stage of learning litigation at the initial stage. Take that little bit pain, pill of a pain, initial stages, which will literally help you shine like a diamond at the end of the day in your career.
Well, this was Mr. Shah, everyone. Thank you, Mr. Shah. This has been a great session, and I believe a lot of technology we have talked about, and a lot of technology is there around all of us, but technology is good only when it works. It was not really working well for us, but I guess the intent was there, and this has gone really good. I hope you enjoyed the session because I really did.
Yes, I certainly enjoyed the session. And to just end up, I would once again like to thank the ClickAway creators and the Let's Talk World for having bestowed me with this award, especially at the time when we completed a journey of a decade. Nothing could have ended better than this. And also, I would like to congratulate all the Singapore awardees in advance for the achievements they have achieved. Thank you so much.
Well, thank you very much, sir, Mr. Shah. This has been our pleasure, and thank you for showing your firm belief in us as an organization. And we are, I'm not sure, but I believe that we'll witness him again joining in our future conferences, not in Singapore, but in Dubai or in London. So let's stay tuned. And thank you very much, Mr. Shah, for
And
joining us for the
I'll
session.
be, I'll be
This has been a
definitely missing,
great.
will be definitely be missing Singapore.
Yeah, I would say so. Yes, certainly you are, but I believe that you will not miss our future conferences. So let's look at it that way, and we look forward to having a chat with you again on some other trending topics in the international legal industry. So thank you very much, and for our viewers, if you like this chat with Mr. Ishan Shah, I want you to like this video, to share this video, and click on that red button to subscribe. Click on the Creators YouTube channel to appreciate what we do, and we have more coming in from legal industry leaders like Mr. Shant Shah himself. This was Sagar for Let's Talk Gold signing off.